I welcome everyone to this, the 36th meeting of the Justice Committee in 2013. I can ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when switched to silent. No apologies have been received. Item 1. The committee is invited to consider items 5, 6 and 7 in private. Item 5 is consideration of our next steps and the evidence received in relation to the supplementary LCM and the Antisocial Behaviour, Crime and Policing Bill following our session today. Item 6 is consideration of EU issues and item 7 is consideration of our work programme. Are you agreeable to taking these items in private? Oh, you're so sweet. Item 2, a supplementary LCM and Antisocial Behaviour, Crime and Policing Bill. This is an evidence session on that LCM. This follows our evidence session with the Crown Office, Police Scotland and Women's Aid Groups on the forced marriage provisions in the bill a couple of weeks ago. Members will see that we received a letter from the Minister on Friday, copies of which are in front of you. The letter explains that the Government now intends the maximum sentence for forcing someone to marry to be 7 years rather than 2, and so the LCM has been revised accordingly. So I welcome to the meeting Shona Robertson, Minister for Commonwealth Games and Sport and Scottish Government officials, Leslie Irvin, Team Leader, Equality, Human Rights and Third Sector Division, Ian Fleming, Policy Manager, Public Protection Unit, Keith Main, Policy Manager, Police Powers Unit, and Stuart Fubister, Legal Services. I understand, Minister, you wish to make a short opening statement. Thank you very much.
Thanks, Convener. This LCM introduces provisions criminalising forced marriage. The Forced Marriage Act in 2011 was a clear statement of our intention to work towards its eradication by making breach of FMPO an offence. We have kept in view developments in the UK and internationally in relation to the response to forced marriage. In June of 2012, the UK Government became a signatory to the Istanbul Convention. Article 37 requires forced marriage to be a criminal offence. We understand that the existing legislation in Scotland does not wholly meet the relevant article. Criminalising will ensure that Scotland can comply with the relevant article, and forced marriage legislation and protection is consistent across the UK. The UK Government timescale for the potential inclusion of an LCM in the Antisocial Behaviour, Crime and Policing Bill did not allow for public consultation. Discussions continue with stakeholders and Westminster officials on this issue, and we were aware that there would, of course, be an opportunity to feed in views to the Justice Committee in their consideration of the LCM. We intend to facilitate the change by working collaboratively with stakeholders to develop guidance for statutory bodies and with support organisations to carry out awareness-raising work to ensure that communities understand the changes. The bill also introduces sexual harm prevention orders and sexual risk orders to replace sexual offences prevention orders, risk of sexual harm orders and foreign travel orders for England and Wales. These matters are devolved to Scottish ministers. However, the UK and Scottish governments wish to avoid the loophole that would exist if breaching these new orders was not an offence in Scotland. A similar approach was taken in relation to serious crime prevention orders in the Serious Crime Bill 2007. We continue to look at legislative and other ways of ensuring that our law enforcement agencies are provided with the relevant powers and processes to protect us, and we're giving full consideration to the Home Office measures and how they might affect Scotland. We already legislated through the Criminal Justice and Licensing Act 2010 to strengthen Scotland's sexual offences prevention order and risk of sexual harm order regimes by allowing for the imposition of positive obligations where deemed appropriate by a court. Such positive obligations have been well received by practitioners, and we consider that they are a particular strength of the Scottish provisions and may already address several of the difficulties identified by the Home Office. Liaison is taking place with the Home Office to ensure that the Scottish orders remain enforceable in England and Wales. And finally, the final element of the legislative consent motion relates to firearms offences. It's essentially a technical amendment which reflects the introduction of a new offence in the Firearms 1968 Act, the offence of possession with intent to supply. Firearms law is in the main reserved, and the change to the 1968 Act aims to strengthen firearms control. The LCM is needed to ensure that powers over licensing of certain weapons, which have already been devolved to Scottish ministers, are extended to include this new offence. Without the LCM, there's a danger that firearms controls in Scotland would be less stringent than south of the border. We don't believe that this should be the case and have therefore agreed that the amendment and the new offence should apply equally in Scotland. This LCM will achieve these objectives.
Thank you, Minister. I'd say to the committee, I've got a feeling that I'm not prejudging, but I've got a feeling that the most and only particularly controversial one is to do with the forced marriage criminalisation. So I think it would be useful to deal with that first, and then we can deal with the other orders. Are you content to do that? Right. So questions, please. I'll take Sandra first this time, then Margaret. You were both on the committee that dealt with the civil legislation. Thank you, Sandra.
Thank you very much, Convener, and good morning. Minister, we heard from Lily Greenham of Women's Aid and others, Shakti Women's Aid and others, in regards to the forced marriage legislation, the difficulties that they feel they would have here in Scotland. And basically the legislation, which is already in place, does, fit the bill, as you might say. And it does fit this Istanbul Convention. However, your comments earlier on there, could you perhaps expand a little bit on that in regards to why you believe that the current legislation as it stands, and Margaret may come forward with more information on that, it doesn't fit the bill, whereas, obviously Women's Aid and others have said that it does?
Yeah, I mean, we clearly disagree with them on that, which is an unusual position because usually we agree with them on most things. But on this, we don't agree. Our advice is clear that we believe that it has to be made a criminal offence for it to comply with the Istanbul Convention. That's our clear understanding. I think it's worth saying and noting that the civil remedies available, the forced marriage protection orders, will still be there as an option. So the civil remedies would be there alongside.
The point the committee appreciates they will be side by side, but that it may destroy, as my colleague is saying, may destroy in fact the good work that's been done under the civil legislation. We recognise both will exist.
Yeah, I think it's worth saying as well that we believe that that this is actually the right thing to do, that making it a criminal offence is the right thing to do because of the repugnant nature of forced marriage. And I think also we should ask ourselves the question that given that there is a criminal law in many other aspects that would apply to family members, why would forced marriage be any different from that? So if you were taking, for example, domestic violence or sexual abuse, which of course can involve criminal acts by family members, why would we make forced marriage different from that in terms of the criminal law? So I believe very strongly, and the Scottish Government believes very strongly, this is the right thing to do. I think countries across Europe and across the world are looking at criminalising forced marriage, and I don't want Scotland to be in a weaker position and perceived to be in a weaker position than many other countries across the world who are going down this particular route.
Of course.
Thank you, Convener. Regarding the civil legislation which was put forward, which obviously said Women's Aid and Shakti and others believe it's not just the fact of forced marriage, it's a cultural issue as well. And you mentioned the fact that will work side by side. Just the aspect of when you're working towards someone reports, obviously, a forced marriage, would we go through the civil process before the criminal process kicked in?
Well, essentially, the person would have the choice if they wanted to use a civil remedy. Obviously, it would be up to the prosecutors if they wanted to use the criminal law in terms of what public interest might be, and obviously we don't need the requirement and consent of the victim to go down that route. However, for the victim themselves, they would still, of course, have the civil remedies available. I think it's worth maybe saying, I'll bring some of the officials in, that in terms of the protection orders can serve very much as a very early stage in terms of avoiding the risk potentially of forced marriage. So you could see how a protection order could be used where there may be a risk of forced marriage before, in fact, any criminal offence had been committed. I don't know if perhaps, Leslie, do you want to maybe say a little bit more about that in terms of how an individual might use those?
Thank you, Minister. Yes, the Minister's absolutely right. Both will be in place. There'll be a number of different factors that would need to be taken into account in each case to decide which route you would go down. The amount of evidence available would be one, because obviously for the civil test of evidence is a lesser one than the criminal test of evidence. But also, I think, importantly, a lot of the potential victims are children. They're young people. And we already have very strong child protection procedures that come into play in these cases and would still come into play in the same way. So there's absolutely no way that protection would be jeopardised for potential victims by this criminalising. In fact, our view is very strongly that it will increase protection, and as the Minister has said, there is some international evidence that it does actually increase reporting rather than reduce it.
I'll let Margaret in now. Margaret, and then Elaine.
Good morning. Minister, I wonder if you could spell out exactly why, in the Scottish Government's opinion, Article 37 is being breached as the law currently stands.
Well, our interpretation of the Istanbul Convention is that it requires forced marriage to be made a criminal offence. I know others disagree with that, although I think the Law Society, although they may have concerns about LCM route, as I understand it, I think their interpretation is a similar one, that the convention requires the forced marriage to become a criminal offence. Stuart, do you want to add to that?
Yes, I think I'm not sure I quite understand the view that it's possible to perceive existing Scottish legislation as delivering on the commitment in the Istanbul Convention. Certain conduct that might be involved in forcing someone to marry may well be criminal if it involves physical violence, abduction, things like that. But there is no existing offence, obviously, of forcing someone into a marriage. The fact that a criminal offence will result if someone breaches a protection order under the 2011 Act isn't sufficient to meet the Istanbul Convention requirement. Obviously, not all circumstances will involve an order being in existence under the 2011 Act.
Would it be possible, therefore, to extend the orders and apply them to someone who was in a forced marriage just now, seeking to extricate themselves from that forced marriage, and then have the protection of a forced marriage prevention order in place? And if that was breached, it would then become a criminal offence, because we heard from evidence some partners in the marriage may not even be aware that it was a forced marriage. And to turn to the Minister's point about, this fear of criminalising some members of the family, where in domestic abuse there is no such sort of fear or apprehension, is a different situation from domestic abuse, because we heard quite clearly that a lot of these people in the forced marriage hope at one time they can return to the family once they're out of the forced marriage. In domestic abuse, that's very rarely the case.
The breach of an order already would you could carry a 2-year, I think a maximum of 2-year sentence. So it already is a criminal offence to breach an order.
Marriage. What I'm suggesting is you're in a forced marriage, and that forced marriage protection orders are then extended to cover that situation where you're trying to extricate yourself from it, and only at that point, if they're breached, would it be
the existing
offence.
The 2011 Act, in terms of Section 1.1, a protection order can be made in respect to someone who has been forced into a marriage. So it isn't a situation that it's only before marriage that a protection order can be granted. But hinging anything around the existence of a protection order means prior identification of that situation, someone applying for an order, then solely to enable criminal proceedings. It seems an unnecessary step.
I think that the whole thing is getting this right and putting in the very best law to encourage people to come forward. And we know there are cultural issues there. We've heard evidence about criminalising it per se will just mean that people won't be inclined to come forward. So I suppose I'm asking again, couldn't that be considered as a way forward? And also the suggestion, if we're wanting to send out a deterrent message, make it an aggravated offence when a forced marriage protection order is actually breached, sends out a very strong message about how severely this crime is looked at.
If I could just come back on the issue of people coming forward, I mean, the evidence that has emerged so far, and I think obviously as more countries criminalise forced marriage, the more evidence will appear. But at the moment, Norway, Denmark, Germany, Austria, Malta, Belgium and Cyprus have already criminalised forced marriage. And since Denmark criminalised forced marriage back in 2008, a Copenhagen-based organisation called LOC reported an increase in young people coming forward. Other grassroots organisations in other countries which have criminalised forced marriage report that they've seen a 50% increase in the reporting of forced marriage. So in terms of whether or not people are more likely to come forward, at the moment there are actually very few, if any, I don't think there's any who have come forward for an annulment of forced marriage. Is that the case, Leslie? So I'm not sure if you look at the evidence about what's encouraging people to come forward. There is a set of evidence in those countries that have criminalised forced marriage where there does appear to be an increase in reporting, and under our current civil legislation, there are no people who have come forward in the last 2 years to annul a forced marriage. So my indication would be that from the albeit limited evidence there is, it seems to be more on the side of the criminalisation of forced marriage actually encouraging reporting to take place.
Why would that be the case? People are reluctant to come forward when it's a civil matter. Why would they become more enthusiastic to come forward when it's a criminal matter? It would seem to me to argue the opposite. Well, and I think the committee are quite sort of sceptical about just taking the view that what works in one country necessarily works in the culture of another legal framework.
I accept that, convener, but I think that what my reading of the evidence in other countries would be that because forced marriage is a criminal offence, the reporting of it, not necessarily by the victim, has increased. Okay, so
that's a very different thing when it's not by the victim. What was the victim's position in that, in the data that you have?
Well, as I say, I think the data we have is fairly top line, but we can get more detail to you. But from the limited evidence we have, I think it shows that there's certainly not evidence to say that it stops people reporting or others reporting on behalf of that person.
I think that's the key, others reporting. What we're concerned about, the people who are in the middle of this maelstrom reporting. Margaret.
Just a final point, Minister, that given the complexity of this and the conflicting evidence we've heard, shouldn't there be more of a consultation on it, and shouldn't there have been more of a consultation on it?
Well, as you're aware, the UK government itself did consult, and the findings from that consultation were very much in favour of the criminalising of forced marriage. Clearly, because of the timeframes involved, a specific Scottish consultation hasn't been possible. But if you look at the UK consultation evidence, it would tend to suggest that there is a support for the criminalisation of forced marriage. I think it would be fair to say that had we not gone down the route of criminalising forced marriage and had a different what might be perceived weaker law in Scotland on forced marriage compared to the rest of the UK and other European countries that are going down this route, I think we may well have been criticised for that. And I accept the timeframes are not ideal, and in an ideal world we probably would have wanted to have done more of a specific Scottish consultation, although the LCM, the Justice Committee, has allowed some of that debate to take place. But in terms of timeframes, we discussed at length what the options might be, what alternative vehicles there might be for this piece of legislation, and came to the conclusion that this was timely and the best, most straightforward way of ensuring consistency.
I think it's strange, Minister, that under our distinct Scottish system of criminal justice, that we should be relying on consultation in England, who have a different approach to it. And in fact, the approach we looked at in 2011 was fully understanding the position in the UK and moving forward with a solution that we thought was actually better here.
Yeah, but
and
since then
again,
we've had
it seems to me that we shouldn't be rushing this. It's more important to get it right.
Well, but since then we've had the Istanbul Convention, which we're very clear requires the forced marriage to be a criminal offence in order to be a signatory to that. The women's organisations that gave evidence to you wanted us to be a signatory to the Istanbul Convention. Where the disagreement is what's required in order to be that. And we are very clear, the UK government is very clear, that it requires to be a criminal offence in order to be a signatory. So if you boil it all down, I think there fundamentally is where the disagreement lies. Everybody is in agreement. We all want to be signatories and ratify the Istanbul Convention. But we are very clear, and the UK government are very clear, that in order to do that, forced marriage has to be a criminal offence.
Yeah, why don't we do our own legislation?
Well, we could have done that, and we debated at length around the options and whether or not there were other vehicles that we could use, or whether we could bring our own legislation. I think the judgment that was made was that time-wise that was going to take a much longer period of time to achieve. And if we believe that actually forced marriage should be a criminal offence, as I do, then in my view it is better to make it so, with the 7-year penalties that come with that, and send out a very, very strong message that Scotland is going to make forced marriage a criminal offence and take a very, very hard line on forced marriage.
I think the position wouldn't be that we don't think that at some point, it would be appropriate to make it a criminal offence. I think the fact that this committee probably feels that we're going quite quickly into something where the civil legislation is only bedded in for a year, and presumably if you were to introduce legislation in Scotland to criminalise forced marriage, the fact that intention was there would show that you weren't in breach of anything, because you're going about it, but you just want to take your time and have a proper and thorough consultation. Because I know the Law Society have accepted this, but reluctantly. And I think what concerns the committee is that those who are at the sharp end, who agree with the Minister in due course, do agree, but have a feeling that by doing it like this, in this way, and at this time, it's counterproductive. And that's, I think, generally, I may be wrong, but I think the committee generally, am I correct, has that feeling about it, that there's an issue here about getting it right for those that matter. I'll take in Elaine. I've got another supplementary, unless others have got other ones. But Rod, you want in afterwards, do you? Right, Elaine and Rod, please. I've got John first, then Rod. Thanks, John.
I'm just wondering when it was that this problem with the Istanbul Convention was first realised, because the Istanbul Convention was signed in 2011 and the Forced Marriage Etc. Scotland Act was also passed in 2011. So when did the government become aware that there was a problem with the legislation which had just been passed?
Thank you, Minister. The UK signed the Istanbul Convention in June last year, 2012. So that was sometime after we passed our Forced Marriage Act in Scotland. And it was subsequent to that when the UK government, in common with many other governments, signed the convention, and then had to look at the process of ratification and what that would involve. And at that point, there was consultation with officials around the UK about whether or not we were already compliant, and it was agreed that we were not compliant either in Scotland or in England and Wales because of having not criminalised forced marriage. We obviously in Scotland, as has been pointed out, were slightly ahead of England in that we'd criminalised breach already in our 2011 Act, but we hadn't obviously gone to the next stage to criminalise forced marriage itself.
So, the Minister is now saying that she believes it's the right thing to do, so why wasn't it the right thing to do 2 years ago? We could have criminalised it 2 years ago.
Well,
consultation about it.
I think, as Leslie has explained, when the UK government signed the Istanbul Convention, it became clear that ratification required forced marriage to become a criminal offence. I don't think that was apparent back in 2011. So it's since then that that legal position has been established, if you like.
I think that's fair. I think You want to go on?
No, it's just, I mean, because the Minister said it was the right thing to do. So if it was the right thing to do, surely it would have been the right thing to do 2 years ago, whether or not it was in contravention of the Istanbul Convention. You know, we've only just passed that legislation a couple of years ago.
I think the Minister's saying it's now mandatory is the position, perhaps. But we'll let John Finney come in now, and then I've got Roderick. Please, John.
Thank you, Convener. So it is about the relationship between the existing civil legislation and this proposal. Is it your quite clear position that a marriage of both the, perhaps unfortunate use of a conjoining of the civil and existing criminal law in Scotland is insufficient to meet these terms then? So a breach being a criminal offence, a breach of the civil legislation being a criminal offence, plus all the abduction, assault, all the other crimes that exist, that wouldn't constitute?
No, the breach of the order is a criminal offence. That's the only part which would be is a criminal offence under the existing legislation, a breach of the order. We're very clear that that does not constitute the requirement for ratification of the Istanbul Convention. The UK Government are similarly very clear on that as well.
Even when taken in line with comments that were made previously about the law of abduction, assault, rape, whatever? No,
but I'll let Stuart elaborate on that.
The shortfall is basically the 2011 Act will only cover circumstances where an application has been made and an order put in place, so that someone committing the offence of forced marriage will commit the offence under existing law only if they've been pre-warned, if you like, by an order not to do a specific thing. That can't be enough to criminalise forced marriage as such.
Transitional arrangements that could be put in place that would...
Not if we are to put ourselves in a position where the UK can ratify the Istanbul Convention.
Okay, thanks. Can I ask about the process we've gone through here, which seems very accelerated, and to deliver something that would bring about a 7-year period in imprisonment, it does seem very speedy and, you know, without the consultation that you would normally anticipate with something of that gravity.
Well, I do accept that it's a very accelerated time frame. I believe, though, the matter is of such importance in terms of making sure that in Scotland we have the most robust legislation around forced marriage, and given the direction of travel, not just by the rest of the UK but other European countries, I believe that is the right thing to do, and we have this vehicle here and now to be able to do it. That then becomes a judgment of whether that's the right thing to do or not. In order to overcome some of the concerns, we are planning, it wouldn't just be the legislation, there obviously will be an awareness raising campaign around that, a campaign of information. We also want to undertake some research to go alongside the legislation to further understand some of the cultural issues, some of the barriers to reporting, whether it's under the civil or new criminal legislation, and to what other measures might help women to come forward, whether or not that's using the civil or criminal law. So we would intend to undertake some research alongside this legislation in order to perhaps build on what is, I would accept, some fairly limited evidence at the moment. I would like us to have far more evidence about what's actually going on within communities and within families, and to support people. And if that means us giving additional support around supporting people to come forward, then that might help us to look at what's required in that light. So that research will be going ahead anyway.
Can I ask, has there been any assessment done of potential damage of relationships, given the very clear indications of no support for this proposal coming from the people who are directly involved on a day-to-day basis?
Well, it's not quite true to say that there's no support. The Sahelia, this organisation Sahelia, which are based in Edinburgh, as I understand it, are supportive of the legislation. Leslie, do you want to say a little bit more about their position?
Thank you, Minister. Yes, Sahelia is a minority ethnic women's organisation that does a lot of important support work with women from many of the communities affected by forced marriage and other forms of honour-based violence. And they view that it's important for the government to adhere to the letter as well as the spirit of the Istanbul Convention. So they are supportive of the need to criminalise in order to comply. They actually believe that it will strengthen support work and preventative work, and they feel that forced marriage should be in line with other abusive practices within the family, as the Minister referred to earlier, such as domestic violence and sexual abuse. Also, Karma Nirvana, which is probably the leading UK organisation working on forced marriage, carried out a questionnaire. They got over 2,000 respondents, and the results of that were that 96% believed that forced marriage should become a criminal offence, and 71% believed that a criminal offence would not deter victims from reporting. So there are clearly mixed views about this. As the Minister has acknowledged that some of our Scottish stakeholders are of a different view from us. But I think it's important to reflect that views are mixed. Amina, the Muslim Women's Resource Centre, as well, carried out a number of focus groups with women using their service, and they found mixed responses there. Some were against criminalisation, some were for. So at this stage in our knowledge, we don't actually know what the effect will be. We don't have any evidence in the UK about what the effect will be, but as the Minister has said, we're keen to do further research, find out what the position is, and get more detail, which we will give to the committee about how matters have rolled out in countries in Europe where they have gone ahead with criminalisation.
I think that's the problem. The key phrase at this stage in our knowledge is the issue. I mean, some of these parties you've mentioned, organisations, we've not heard from them, so we don't know about what their views are, and always the numbers game and percentages. You know, when it says, I can't remember the figure, what was the number that you had the figure for? How many? 57%. I think it was 57% in the UK. 54% were agreeable to criminalising, and the other was the 37% were against. But percentages, you know, depends who's saying it. I think the issue, John, you go again, is that you've made the point for us, and I think the point making that we will look at and do research while legislation is being enacted seems to me topsy-turvy. You do the research first.
And I just glad that we would be doing that research anyway, because we feel that we need more research whether or not this piece of legislation was being enacted. All I'm saying is that the research will help us as we go forward with this legislation to see whether or not the position in Scotland mirrors some of the other European countries in terms of the reporting increasing. We want to monitor that. We want to understand better why that might be the case and whether that will be the case in Scotland as well. And we think it's prudent to put that research into place alongside this legislation, and also to understand why there's been, for example, no one coming forward to use the civil legislation to annul a forced marriage. Why is that? Why has no one come forward? And I think we need research on that as well. So
I think we'd be saying we've got to find that out first. John?
Yeah, thank you. It was remiss of me to suggest that it was total opposition, but clearly I was interested in more the relationship with the organisations who don't support this proposal and who you would seek to engage with. I wonder, can I move to, and I think you mentioned Amina Muslim Women's Resource Centre, and their evidence to us, and I quote here, they say, furthermore, we would emphasise that more could be done to ensure a robust and effective response to forced marriage disclosures by providing mandatory training for all frontline service providers, be that police, education, social work or health. Is that something that's going to be actively considered?
Well, certainly we would want to, as part of taking forward this legislation, make sure that all of our frontline staff are well trained and are informed about the legislation, and importantly, I think, how the civil legislation and criminal legislation sit beside each other, and to make sure people are well informed about that, as well as raising awareness within communities also. So yes, this was a short answer to that, is yes. Can I just go back to say about the organisations that that have a different view to us? I think the important thing, though, is where we all agree is that the Istanbul Convention should be signed and ratified. Where we disagree is what's required in order to do that. And I think that's where we feel we're very clear. UK government are saying exactly the same. So I wonder if that was to be proven beyond all reasonable doubt, if you like.
Could we have corroboration, Minister?
Whether the women's organisations would take a different view, I don't know, and they would obviously have to answer that for themselves. But, you know, it's fair to say that 99.9% of the time we are always in the same place as those other organisations. We have a very strong partnership and work with them very closely. This is quite an unusual position, and it very much boils down to whether or not you agree or disagree with the requirement of forced marriage to be a criminal offence in order to ratify the Istanbul Convention. We are very clear that that is the case.
Thank you very much.
Roderick.
Morning, panel. Morning, Minister. As I understand it, the bill makes it a criminal offence, amongst other things, for a person to use violence, threats or any other form of coercion for the purpose of causing another person to enter into a marriage without their free and full consent. We've heard evidence from the Crown that they consider that a number of current offences could be considered in relation to forced marriage, but that provision, which I've just read out, is much more comprehensive and would cover the full spectrum of behaviours which is not necessarily covered at the present time. Would the panel like to comment on that point? They agree with the Crown on that?
Yeah, I think I would entirely agree with that, and I think it's in line with what I said earlier. It's, you know, certain conduct that may emerge when someone's being forced into a marriage, yes, will be criminal under existing law. But I don't see how one can possibly say that all conduct that would constitute forcing someone into marriage is a criminal offence at present.
So to that extent, if we agree to this LCM, we will be, shall we say, providing a more comprehensive response.
Yes, and delivering the needs of the Istanbul Convention.
Thank you.
It's not possible under the purposes of the existing legislation to amend it. The existing forced marriage legislation, it's not possible to amend it, given the, I don't know, I haven't got the purposes in front of me.
The present legislation is that it all depends on applications being made to set up an order in order to produce a criminal situation.
So if we wanted something else in Scotland, I'm not saying we do, but if we did, it'd have to be a separate piece of legislation. That's fine. And I think I wanted to ask, before I bring somebody else, is a couple of things. Children, you mentioned children. I have concerns that children may be loath, they're very loath anyway, to report on parents or family members anyway, generally, whether it's a forced marriage or otherwise. It's a social work. They think the social work department's going to come in, take the parents away and everything like that. You know, the effect on children, if this is, you know, if we bring in, criminalise it from, let's say, from the start pretty early on, because that'll be up to the Crown Office to decide whether or not it should be a criminal matter or not. They take it on in that way. Might inhibit, again, be counterproductive. A, inhibit children from saying anything, and B, it places professionals in a difficult position where perhaps now, when it's reported to them by children, it's initially perhaps a civil matter and they're not unhappy you know, with their duty of confidentiality, but sometimes you have to go over that, beyond that, to report it, but they might find it difficult if it's a criminalising offence. And I'm just thinking of the two sets here, children reluctant to say, and the position that professionals dealing with children may be put on as a consequence of this legislation if it comes in. I'd like somebody, Minister, to comment.
Well, yeah, I'll bring in others in a minute, but my understanding is that the position in relation to young people under 16 won't actually change, that if a disclosure was made by a young person, then the relevant child protection procedures would be activated as they are now. So,
but would they do it if they thought what they were doing was reporting parents or aunties and uncles of a criminal offence? You know, that's my point. It's difficult just now for them. Would it be more difficult for them?
But if they did it just now, then child protection procedures would be enacted.
Yes.
If they did it then, child protection procedures
would
be
they
enacted.
do it? See, at the moment they know that if they do it, it's a civil offence.
Well, I suppose
Sorry,
you could,
no? Alison, yes?
I'm not sure children really know the difference between civil and criminal.
No.
Well,
So-
I
so
think
you
that's
think-
a fair point. If they're going to report, they'll report, and child protection procedures would be enacted in either case. I think what's important...
Can I just dispute with my colleague here that I think children, if you're going to do this education and tell people all about it, I think children in communities, remember children's up to 16, will be an awareness of the fact some children it is perhaps a criminal offence. I just raised that issue with you. I think it's difficult for children anyway to report.
Sure, but I suppose if you think about other criminal offences that might take place within the family environment, I mean, we're always encouraging children to speak out and tell us what's happening within the family environment. Why should forced marriage be any different from that? I mean, I know it's difficult for children, but the criminal law exists, whether that's disclosing domestic violence potentially or disclosing sexual abuse.
But this is a big cultural thing. This is ramifications for you within a community beyond. Is something quite different, because what I was also looking at when you said, what if a community is to be criminalised, not an individual, but a group of people within an extended family and community beyond who are party to an action, such as would be criminal under this. It's very different from dealing, at the moment, it's very different from dealing within, say, domestic violence situations where a child may report it.
But I think what's important is that the support within the community is going to be very important itself in terms of making sure that where a crime has been committed involving forced marriage, that is reported. And what we need to do, whether or not it's civil or criminal legislation, is really to make sure that the community feels supported in order to for people to either be encouraged to report themselves if they're directly affected, or indeed for third parties to report that a forced marriage.
It may be the community that's being criminalised. That's the difference here. But there may be whatever we describe community as, whether it's an extended family or even a larger community, the community itself will be tinged with criminality in this. That's my point. It's different in this particular circumstance. And what interested me in the evidence we had about domestic violence was how it was progressive. I know we wish things were faster, but how the culture change came first with the Matrimonial Homes Family Protection Scotland Act, which gave us exclusion orders and all kinds of protections to married couples, and was extended to civil partners. And then we moved on to recognising domestic violence as an issue, and the women's groups that we saw with regard to this drew that parallel of taking it forward so a community comes with you rather than against you from what's being done.
We aren't saying anything that the community are against. I mean,
Sorry, Alison,
Leslie, you want to...
Minister, I think the parallel with work on domestic abuse is a good one to draw on, and in particular domestic abuse as it affects minority ethnic communities, where very often there are other family members involved. I mean, that's a key cultural difference there, where it's often the female members of the family, mother-in-law, the aunties-in-law and so on, as well as the male partner. And so therefore, if you're disclosing domestic abuse in that kind of context, then you are potentially criminalising a larger group of people. Same would go with female genital mutilation, which is also, of course, a criminal offence, and where it involves family members, often the mothers, aunts, and so on, and potentially criminalising large numbers of people. And we have said in those instances that it's very important to have a powerful message to victims that what is being done to you is a very, very bad thing, and that society is not prepared to stand by and support that. So I think there's a number of parallels there which you can read, which would suggest that this is the right way to go forward. We're not aware of, I mean, obviously the organisations that have given evidence to you have a particular view, and we respect that and we understand their concerns. which we understand are coming from the same places that we're coming from, which is an aspiration to do the best that we can for victims. But we're not aware of communities themselves expressing those views, which is why the Minister's referral to research, so that we can understand if there are barriers and see what we can do to overcome those, is an important way forward.
Sorry, Alison.
Thank you.
I did my dinger there a little bit. I just don't do it often, but I was doing it a little bit.
Actually, I found it a very useful evidence session, and I've been persuaded by what the Minister has to say. She's spoken quite strongly in defence of the proposals, and you've identified quite clearly that there's a weakness in the civil system at the moment, and that it needs people to self-refer, and therefore it can't possibly absolutely meet the Istanbul Convention. I think where I'm left is that like other colleagues concerned about the speed and the impact that will have, there's no point in saying what if we'd done a bit more consultation when you saw it coming down the line. I wonder what resources you think need to be there to support the community groups and the groups that work at the moment, whether or not you need to kind of ramp up the resources that would be there.
I think that's a good question. We'll continue those discussions with the organisations that we work closely with. We want to make sure that we support people to the maximum, the victims particularly, but that we also support communities, because at the end of the day we want to eradicate forced marriage, and we want to use the law as one part of the toolbox to do that. But the rest of the toolbox is about the supporting organisations that are on the ground, that are potentially working with potential victims. So that's a discussion that we'll continue to have, and if they require additional support to carry out that job, then that's obviously something that we would want to take forward.
Sorry, I was half listening here to just to get a kind of sense of, having raised the issue of speed, get an idea of the timetable here for the committee. I think you're advising me, I think we've got to report by the end of January, mid-January. Commencement of this order, were the Parliament to agree to it, would be when?
Arrangements under the UK bill as it stands just now are that Scottish ministers would be responsible for a commencement order to bring the forced marriage provisions into force.
So what's in the thought process of a commencement order? What are you thinking about when you're talking about doing research at this time and continue it? Gives an idea of what's.
Yeah, I mean, I suppose my only concern would be that we wouldn't want it to be too far off the time frame for the commencement of legislation south of the border, because we obviously are very keen that there is not a perception that Scotland does not have the same robust set of legislation dealing with forced marriage. The commencement south of the border is, do we know when that is?
Don't, I'm afraid, when the bill is still going through at Westminster.
But it's likely to be, what, into middle of next year?
I wouldn't have thought any earlier.
No. So middle of next year, we understand, although, as you know, it's always hard to be precise with what processes south of the border.
Yes.
But we would say certainly well into next year before that's likely to be enacted. Now, given we obviously can enact and commence legislation ourselves when we choose to. As I say, I wouldn't want it to be too out of step with the time frame south of the border, but obviously we're cognisant of some of the discussion that we've had here today as well, in terms of awareness raising and making sure that everyone's aware of the forthcoming.
That's helpful.
change.
That gives us an idea. Margaret,
Just a point of clarification on Alison McInnes's point. She's convinced because it requires, as she understands, people to self-refer. My understanding was, and I could be wrong, that the Forced Marriage Protection Orders doesn't require self-referral. The police can do it, other parties can
Ability for local authorities or the Lord Advocate on behalf of the Crown to seek protection orders, but
So
there must be knowledge, obviously, on the part of these.
Yes, absolutely.
Would have had to have reported to someone who would then.
Is that the case? That the person would have to?
Well, local authority or Lord Advocate it wouldn't necessarily have to come from the individual who is being forced into marriage, but they obviously have to have awareness of the situation before they would think
That's
of
my
going to court.
understanding too, and therefore, you know.
But it's unlikely, I suppose, you would have awareness unless the person themselves had that discussion. That would be the most kind of logical way that a third
Similarly,
party
if we
would have
pass
found.
what the Minister's suggesting, it would be the same route. That person would still have to have knowledge. I don't see there's any difference between the two
The
situations.
prosecuting authorities would have to have knowledge of they would have to have evidence. Yeah.
I want to. I don't know whether it's a matter for Spice. I'm just floating it over at Spice, or whether for the ministerial team to give us more information about what's happened in the other European countries that the Minister referred to, when the number of people referring whether or not they were in fact the victims or parties and the consequences thereof. You know what I think, because I'm making a presumption, I don't know. Again, do these countries also have civil legislation in place running in parallel? I don't know. If you don't know, Spice is going to have to find out for us, but I think it would be very useful for the committee to know, as reference is made to the practice elsewhere. So I'll leave it like that. Can I thank the Minister and just say I think the committee is exactly wanting to do very much the same thing, but you can hear our concerns, which I know you will share, in that we're in a rather accelerated position. We'll give that consideration later today. Thank you very much. Thank you. No, moving on. Sorry?
I did actually want to raise another point, but
What point?
just on change in sentencing.
Well, it's gone. It's gone. But that's to comply with the English legislation, Roddy. It's to comply. Suspend for 2 minutes. Thank you. Right, back. And before I move on to the next item, which is further evidence of the Criminal Justice Scotland Bill, can I just take it that members with the other orders in terms of that LCM were content, which are just the continued enforcement cross-border of certain orders. So just for the record, you're content. You're content. That's nice. Item 3. Back to the workplace again, and we're back to talk about corroboration and related provisions of the Criminal Justice Bill. And I welcome our panel of academics, Professor Peter Duff, University of Aberdeen, Professor Pamela Ferguson, University of Aberdeen, Professor Fiona Dundee. Oh, how dare I? Yes. Oh, heavens. Am I forgiven? No, she did. There was a look of not being forgiven. Professor Fiona Raitt of University of Dundee, Professor James Chalmers, University of Glasgow, not Edinburgh, and Professor John Blackie, University of Strathclyde. Can I welcome you all to the panel? And I thank you for your written submissions. We'll go straight to questions from members, please. Christian and then Alison, please.
Good morning. I would like, first of all, to clarify one of the things which we talked about last week. And I'm quite pleased that Malcolm Graham, the Assistant Chief Constable, came back with a clarification. I would like you to hear the clarification and to compare it with the evidence some of you have given in writing. He said, I'm conscientious that those who oppose the proposal often appear, perhaps conveniently, to abbreviate it, simply referring to the abolition of corroboration. I hope that my evidence to the committee assisted in dispelling this popular misunderstanding and clarified that the proposal is to abolish the absolute requirement for corroboration, not corroboration itself. And he added, corroboration will continue to have a place in Scots laws and future within court proceedings. It is simply that our law currently requires that certain particular facts must be technically corroborated before any proceeding can be commenced. And if I go back to you some of the written evidence we received from you, and I would say that some evidence will use the abbreviation of removal of corroborations. If I take, you will know your evidence, but if I take particularly one which is from Dundee, from the University of Dundee, we'll see that we are not satisfied, from the summary, the first line, we are not satisfied that the case for abolition of corroboration has been made. And you had it afterwards, if I may say, that the argument that other jurisdictions do not have corroboration and therefore Scotland is out of line also adds little. There is no corroboration requirement as such in England, but it is our understanding that prosecutors routinely look for corroboration and do not generally prosecute without it. Can I put to the panel that it's exactly what the prosecutors of what Police Scotland are talking about? We are saying we will not remove corroboration, but we're quite happy to have the requirement for corroboration removed, just like in England. Corroboration will still be used.
Well, first of all, I may correct you, police are not prosecutors. I think they'd be happy to be called that. So there we are. It was a long, I was asking for short questions, and I'm glad you've set the bar.
Thank you.
Now, you know how to self-nominate. Just indicate to me if you wish to respond. And I think I should take Dundee as opposed to Aberdeen first. So who would like to respond to that first? Professor Ferguson.
I acknowledge the fact that it's the legislation intends to abolish it as a formal requirement. However, I fail to see why we're having this debate at all if we're saying, but it will be business as usual because prosecutors will still look for it, in which case why not keep it as a formal requirement? But yes, I mean, I do acknowledge the fact that it is something which many jurisdictions look for. And it's quite interesting, actually. Professor Duff and Professor Raitt and I were at a conference in the Netherlands a couple of weeks ago about the presumption of innocence. But over coffee break and lunch break, we asked academics about corroboration in their jurisdictions. And generally speaking, they said, oh no, we've no such thing as corroboration. Scotland's bizarre in having this corroboration requirement. But when you probed a bit more deeply, they all said, but of course no prosecutor would go ahead without what you call corroboration, 2 pieces of evidence. And of course judges will not find someone guilty beyond a reasonable doubt on the basis just of the witness of one complainer. So whether we call it a formal requirement or not, corroboration does operate in many jurisdictions, unofficially, if you like.
So you would agree that we're not talking about the removal of corroboration, but corroboration is likely to stay?
I can't
Professor Duff to the fray.
So just, I don't...
Yes, after
just
Professor
a quick
Ferguson.
point was just, I mean, that would depend on the practice of the prosecution. Yes.
Yes, I mean, that's the problem. I mean, corroboration as a common sense rule of thumb is something we all use in our everyday life. We're more likely to act for confident information, and we're more likely to be confident in that information if it's come from two sources. So as a matter of practice, as an everyday rule, it will still exist. But the important thing about it being a formal requirement, and why I think that response is somewhat disingenuous, is that at the moment a prosecutor will not prosecute, and a judge or a jury cannot convict where there is no corroboration. That's the precaution. And what this is allowing is for a judge or a jury and a prosecutor to go ahead where there is no corroboration and there is a possibility of conviction with no independent evidence. And furthermore, we all know that and prosecutors complain about it, the pressure on them in sexual assault cases, domestic violence cases is very great. There are great political pressures on them to prosecute in every case. And what will happen probably, and clearly what the Justice Minister envisages, is that in cases where there is only one witness to that sexual violence, to that domestic violence, the prosecution will go ahead. That's what prosecutors will be instructed to do. And that brings with it a danger of miscarriages of justice. So it does make a difference having the formal requirement. And as Pamela says, if you take these words literally, then there's going to be no change anyway, so why bother with it? Which is not the message we're being given.
You want back in?
Yeah, I just wanted to hear from Professor Chalmers as well on this point, because he did say, will we express no view on disability of abolishing corporation? We do not support the case made by Carwell Review to justify this proposal. So, again, we're talking about abolishing corporation, just to make it clear that it's not what we are talking about.
Well, we know that. We know that we're not talking about abolishing it per se over everything, but it's the fact that it is currently mandatory. I think that's shorthand. I think, Christian, we don't need to go through that again, but the mandatory requirement for corroboration is what you object to being removed, Professor Chalmers.
Yes, well, can I just say the idea of removing corroboration itself makes no sense. That's not something that could be done. The Police Scotland supplementary submission seems to suggest, well, there will always be the possibility for corroboration. That's not going to be abolished. Now, of course, that could not be abolished unless we actually brought in some kind of rule that prosecutions had to go ahead on one source of evidence only. So the defence of the bill in saying it's not proposing the removal of corroboration itself is a nonsense defence. It's not one to which this committee should pay regard.
Yes, so let Professor Blackie in first, please. Professor Blackie.
Two things I'd like to say. One is that in civil cases where the requirement was abolished in 1988, there have been all sorts of changes of practice, but one couldn't have predicted what they were going to be in 1988. And the second thing is that I think you have to see a requirement, any of the requirements in evidence law, so take hearsay, for example, in criminal evidence law, the fact that they're stated as a requirement is important in that they then become part, if you like, of what is sometimes called in academic literature the protections for an accused. So there really is a complete difference between practice, yes, you're not going to go ahead with cases you don't think you're going to win, and a requirement. Now, I haven't yet said what I mean about that requirement or what I think is desirable, but it is a different thing.
Thank you.
Alison, please.
Yes, I'm glad that Christian Allard raised this new kind of rather strange defence that's been flying around for the last week. It is just a bit of playing around with words, I think, and to try and obfuscate what's actually being proposed. And what's being proposed is quite a significant change in the law. We heard from Sheila McCall last week of the Scottish Human Rights Commission about the concerns that there would be about miscarriages of justice, given that there are very few other safeguards in the system once you remove corroboration in terms of being able to throw a case out of court. Would you like to comment on whether you think there are enough additional safeguards in the bill to avoid miscarriages of justice?
Professor Reid.
Well, I wonder if this is going to sound like a circular argument, because actually I think the fact that there's a requirement for sufficiency of evidence is much more important than many people have recognised or have commented upon. Because, in fact, given the tendency for the legal profession and the judiciary to be quite conservative, they won't need to look very far in their interpretation of sufficiency to find that they discover corroboration would actually provide that sufficiency. So once again, just as we've had the discussion we've had already, I suspect we'll come full circle. And in order for prosecutors or for juries, particularly perhaps, and certainly this would be true, I think, of sexual offences and cases involving domestic abuse, I think, and cases involving children and perhaps vulnerable witnesses generally, I think juries will look to have the security of something equivalent to corroboration in order to achieve sufficiency. They'll be charged by the judge that they have to find sufficiency of evidence. And you would normally find that in two sources.
Okay. Anyone else wish to comment further? Professor Duff.
Yeah, I mean, I think this is one of the issues. You know, taking the broad view, I suspect, well, in fact, I know that the five of us are not of one mind whether corroboration should be abolished or not. Myself, I'm actually on the fence, as it were. But, I mean, I think what we would all...
On the fence, or
I would
tipping
say so
in either?
Teetering.
Teetering which way?
I don't know at the moment. One way, depends on the breeze. But I mean, I think the issue is that, you know, and I come back to your question, this is what we think should be looked at. I mean, I was on the Carloway expert group, and I mean, the majority of that said this has to go to the Scottish Law Commission for a balanced consideration.
That's an interesting point you've made. Were any of the rest of you on the Carloway expert group? Perhaps it should have been declared at the beginning.
Oh, so sorry, I should have...
No, it's not a fault. This is the first time we've heard this, I think. Am I correct? Mm-hmm. Right, so could you just continue with what you said about that?
Well, I mean, I know that the minutes have been made public because a student of mine got them on the on the web and wrote about it in their dissertation. The vast majority of people, the vast majority of experts on the Carloway reference group wanted it referred to the Scottish Law Commission. And I make that point because this was the kind of thing we wanted looked at. If we were to remove corroboration, some of those people were against the removal of corroboration per se. Others, like myself, were ambivalent. But what we all thought was, well, if we are going to remove corroboration, we have to have a very good think about it and what all the other safeguards are. You know, and at the moment, so we have that one view, and of course all the other judges disagree with this, and again want it bumped to the Scottish Law Commission. And I think this is precisely the type of thing that the Scottish Law Commission would be looking at. What kind of safeguards, if we get rid of corroboration, you know, could we get rid of it? Should we get rid of it? They don't have it in most other countries. Fair enough. What other safeguards are there? We've got to come up with the right balance. And what we have, rather plucked out of thin air, is this suggestion at the last moment that the jury majority be changed from the bare majority, with no evidence to support whether that would make any difference or not, no detailed consideration of it. I mean, it is a suggestion that goes back to the Thompson Committee in the 70s, but there's never been any research on it or what its likely impact would be. Now, I think if the thing were to go to the Scottish Law Commission, then it could have a detailed look at what other kind of safeguards we might want, including the one that Fiona mentioned. You know, would sufficiency kind of ensure that you'd be protected from the very credible but lying witness?
Yes, Professor
I would agree with what Professor Duff says. I mean, I think if we think about why we are where we are today, it's because we ended up with the Cadder case, and we had the police having to have solicitors present when interviewing suspects, and as a knock-on effect it was then mooted that we should abolish corroboration, and as a knock-on effect we're now thinking about changing jury majorities. It seems to me this is piecemeal reform. No one's stepping back and taking a broad view of the criminal process, looking at the checks and balances and doing a proper comparative study with other jurisdictions.
Anyone else wish to comment on the panel? Professor Blackie.
Convictions. We know there are some wrongful convictions. There are wrongful convictions in any system, however perfect it is. What we don't know is how many there are, but nor do we know how many wrongful acquittals there are. By that I mean people who have actually committed the offence, but it can't be proved. One of the things that's greatly lacking in Scotland is actually empirical evidence. Other jurisdictions, there's a massive literature from America on the impact of various protections, non-protections being there, on juries' ability to detect unreliability in evidence, which is very, very low according to psychological work, on witnessing as well. So here we are in Scotland, not having addressed any of that interdisciplinary research at all, and coming up with one thought that we get rid of something. And what is needed, I would suggest, is to look at the system holistically. And maybe we would come up with many other changes, which might include this.
Yes, Professor Reid.
Thank you. I wonder if I could just add one more thing to that comment, which is I was struck by a comment that the Lord Advocate made when he gave evidence, and I wasn't looking at the official report when I read this, so I hope it's correct. But I think he gave you the example of two women who were, when they were young girls, were very seriously abused, and the prosecution went ahead, but when it came to the moment of appearing at trial, one of the women simply couldn't do that. And he commented and said, that's the problem with corroboration. And I was very struck because I thought, it's actually nothing to do with corroboration, it's to do with why did a woman not wish to give evidence in court? And that's to do, I think, with the adversarial process rather than anything else, which I think adds to the case for a far more broadening out of what we're looking at, and to look at all the issues that feed into where the corroboration plays a role in the system.
You're also, I think, this week at stage 3 of the Victims and Witnesses Bill, which has its impact on court process and in the way victims and witnesses feel within the court process.
We've heard the Cabinet Secretary stress quite a lot that he wants to widen access to justice, is how he explains it. I wonder what the panel's view is about whether or not this will result in more prosecutions, but not necessarily more convictions.
I think we've already
Professor Chambers, yes.
We've seen evidence, at least in the financial memorandum from Police Scotland and Crown Office, suggesting that they believe there would be additional prosecutions. We know, I think, from evidence in other jurisdictions that it's actually very difficult to get a conviction without corroboration. So the ultimate number of convictions, I think, would be unlikely to go up in that situation. The danger with abolishing corroboration is unlikely to be that you create a significant number of additional wrongful convictions. It's that you let cases through the net, which are really too risky to get to that stage. But the effective numbers, I think, is likely to be small.
Yeah, Women's Aid, I think, correct, Women's Aid said, and I made the point about perhaps then you're sending people to court, which is a risky prosecution and that fails, and the party is acquitted, the accused acquitted, and they took the view that the women would rather go to court. What do you say about that? Because I didn't see court as therapy, but, that, to put it that way, that was better that they got to tell the story, and there would then perhaps be a culture change in the judiciary and in juries. Did you see that? Did you read that evidence and see what we interested in your comments on that?
I can't add anything to your own comments on it there, that there's difficulty with seeing court as a therapeutic process. I think that's not a view that's expressed very often by people who've been through the court process.
Does anybody else want to comment? Did you feel there was merit in that? I mean, it's...
I've certainly heard people from Rape Crisis say that whilst for some women getting the accused into court is a big part of it, for the vast majority they really are looking for a conviction. And I think the danger here is there will be raising of expectations. People will go to police and say, I know it's just my word against his, but that's good enough now because I don't have a corroboration requirement, and it will not be good enough because juries will not convict.
I actually had a question down, and it is the conviction rate and rape is poor. It's about 50%, isn't it? I'm looking at the recent parliamentary question I asked, and it's something like acquitted. Let me just look at this in the rape figures. Yes, it's something like 41% acquitted, not guilty, acquitted, not proven.
These are figures for cases that have already got...
These are figures for 2011-12. I wanted to find out the difference. I think there's more successful prosecutions in domestic abuse and sexual abuse, but rape is a very poor conviction rate.
These are figures for cases that have already got over the corroboration threshold, in the view of Crown Office at least, because they've been taken to court. So abolishing corroboration, I don't think could raise that figure at all. It might raise the number of cases taken to court, but it would be unlikely, in fact it's impossible to see any way in which you could raise the number or proportion of convictions resulting from that.
I'll ask Elaine to come in, please.
Yes, I mean, just to carry on with it, with the theme really that the rationale behind this is the lack of ability to take certain one-on-one crimes into court, such as sexual and domestic abuse. There's also been the case made that there could be a case for retaining corroboration, but with some reform. For example, inclusion of the distress of the victim as a corroborating evidence, or indeed that possibly a definition of what might be considered to be corroboration would be helpful in assessing whether or not some of these cases should be taken to court. And I just wondered what your views on that, whether in fact we should be recommending that the case for reform of corroboration should be further investigated.
Professor Duff.
Well, I think Lord Carloway rightly identified one of the problems is that the law on corroboration is very, very complicated at the moment. And the reason why it's complicated is judges have, on occasion, tried to find a way around it so that they can manage to open the way to conviction for those whom they think are guilty. And in fact, distress already can corroborate. The problem with this, as Lord Carloway says, the law's got very complicated. Nobody really understands it properly. The judges continually try to define it and then finesse their definitions and so on. So actually defining it in statute I don't think would help, because all that would happen is it would be almost impossible anyway, given how complicated it is. And then all that would happen was that would get overlain with another layer of case law, and matters would come back to where they are, where very often nobody knew where they were, and it was very difficult to predict whether there was corroboration. I think, and were you to simplify it greatly, then I think there would be a risk that the conviction, fewer cases would get through that net. So I'm not sure what one does about that. But I mean, again, I think that's something that the Scottish Law Commission could perhaps look at.
Professor Chalmers.
Can I perhaps disagree with that? The committee has before it supplementary...
You wouldn't be academics
Absolutely.
if you didn't disagree. You wouldn't be lawyers if you didn't disagree. You wouldn't be politicians if you didn't disagree.
This is when students complain that we won't tell them the right answer because we don't agree. The committee has before it supplementary evidence from Crown Office, giving a number of case examples, 5 case examples, or really 4, because number 3 isn't an example at all. Now, what is significant about these examples is that none of them are really cases where there's no supporting evidence at all. There's always some supporting evidence thrown into the mix. I'm surprised that in at least some of these cases, Crown Office don't believe that that meets the legal requirement for corroboration, but that appears to be their view.
Can I just ask you, what is the difference between, if you, for the record, corroboration and supporting evidence?
Corroboration...
If you're saying one could have been corroboration...
Corroboration requires supporting evidence on all of the essential elements of the crime and the fact of the accused as the perpetrator. So it's supporting evidence across the board. Now, in some cases with the examples given by the Crown Office, I'm not sure why they took the view that wasn't there. But what's significant from these examples is that they are not seeking to persuade the committee that they really want to bring single witness cases. They appear to be seeking to persuade the committee that they want to bring cases where the supporting evidence is there. Now, that might be achieved by some clarification around the law on corroboration. And Professor Duff mentioned distress as corroboration. One of the problems there, which is flagged on one of these examples, is that the extent to which distress can corroborate is limited. It corroborates certain things and not others. That could potentially be looked at. The second point I wanted to pick up on was the argument that corroboration is complex and that this might be, I think legitimately might be a reason for thinking about abolishing it. We ought to remember that in systems that don't have corroboration, those systems will safeguard against wrongful conviction through a wide range of different measures designed to prevent that happening. Now, actually, in the aggregate, these measures may turn out to be as complicated and confusing as corroboration itself. It's not clear that a system without corroboration is necessarily a more simple system.
Professor Duff, do you wish to retaliate?
No, I mean, I agree with much of what James says. I mean, I think to try and absolutely define corroboration, however, would be very difficult. It perhaps could be done more simply. But I think that once one starts putting in place these other mechanisms, as James mentions, then of course you're going to get arms and legs growing, and you as he says, you will probably end up with as complicated a position. So I mean, I wouldn't actually say abolish corroboration because it's complicated. All all evidentiary doctrines are very complicated. I'm just saying it is complicated, and I'm not sure that one can really address it in an atomistic way, going back to the holistic point made by Professor Blakey, without actually looking at the overall view, the overall thing, and trying to put it in the context of that.
Is it Professor Blakey or Blackie? It's Blackie.
Blakey
Well,
live in the northeast of Scotland, Blackie's live in
I
the
got
south.
Dundee wrong, so you can get something wrong as well. Yes, Professor Blackie.
Yes. I mean, I think, in fact, yes, there are complexities, and the explanation given is exactly correct, that judges have done it in order, if you like, to water down corroboration in cases where it is getting in the way. Although I rather suspect that the routine case that comes up day and day doesn't feel terribly complex, and the complexity maybe in those is with circumstantial evidence rather than the paradigm of two witnesses. Thinking, though, of, if you like, tweaking corroboration, there are quite a lot of jurisdictions around the world that have all sorts of different halfway houses. For instance, in South Africa, there has to be corroboration of confession evidence. In some places, there's an extraordinary range of different crimes, ranging from perjury through speeding, through actually feigned marriages. I'm not terribly keen on those as such. And more important, I think, are those jurisdictions where there are warnings given. The difficulty with that, though, is that if they're discretionary warnings by judges, it of course depends on the judge's understanding, and also they only bite at the end of the trial. So they have no effect on the criminal justice process as a wider thing, starting with police work. Now, however, again, these simply haven't been looked at, and I don't have a firm view on them myself either. I can see a ground for having, say, certain serious crimes, or say before juries only. You know, there are all sorts of permutations, and so that's a reason in itself for having a holistic, wide, in-depth look at the whole system, and the Law Commission is the obvious place to do that.
I'm just looking to see if anybody else wants to enter this discussion at this point. You've got a supplementary here.
Something Professor Chalmers said, you referred to the examples that Lord Advocate gave, and you said you were surprised that some of them hadn't made their way through into the courts. COPFS has recently rearranged the way it deals with some of these cases, and it has specialist markers now, has it not? So would things like that in itself not assist in understanding? You're saying it's very complicated, but if you had a specialist marker that worked on those particular types of cases, then we become much more efficient and more likely to understand the processes that were there.
Yes, I'm absolutely sure that's correct. My understanding of the examples that have been provided by Crown Office is that they're not real examples, because not only have they been anonymised, some details have been changed, and therefore these may not really be cases that actually didn't go through. In fact, I think it's clear that they're not cases that didn't go through in that form. I'm concerned that we're not getting examples of real cases as they stood, obviously with anonymisation. I'm concerned that details have to be changed. It may be that that is only for the purpose of anonymity, but it's impossible to tell, clearly.
So I beg your pardon.
Just come in there. I mean, yes, I mean, I agree. Specialist markers, might well help, and they might be able to spot, as it were, that there is a possibility of corroboration where a less experienced marker doesn't. But I think that the danger is, as I alluded to earlier, is I think that the political pressures in Crown Office are such that there is a great deal of pressure to prosecute all these kinds of cases. And I think, however specialist the markers, they will be aware of the pressure that they should be prosecuting all rape cases. They're already aware of the pressures in domestic violence cases, and they complain constantly about having to prosecute what they regard as minor trivial cases. Now, they may be wrong, they may be right, but that's the pressure they feel. And I think if corroboration goes, they will feel a pressure to prosecute all sexual offence cases, regardless of whether supporting evidence corroboration exists, and that brings with it a danger of miscarriages of justice.
It is related, yeah.
Yes,
it is related. We mentioned earlier on the change in the jury majority. I wondered if you could advise whether if we're going to discuss in the round, or if there were a debate in the round at the Law Commission about what has to be done if corroboration, the requirement for corroboration is abolished, what other factors should be taken into that discussion? What are the other safeguards, if you like, which ought to be considered in conjunction with any consideration of the requirement to abolish it? Abolition for the requirement.
I think we're asking you to write the remit.
Yeah. Just briefly, I mean, not
a brief remit,
briefly,
yes.
not indeed.
A few points, bullet points.
Yeah. I think that the committee already has some evidence in that recent evidence from Professors Ferguson and Wraith, and also from myself. A remit in this situation for the Law Commission might be to consider whether, were corroboration to be abolished, what safeguards would require to be put in place, possibly also to consider whether those safeguards in a package are preferable to corroboration, or retaining corroboration would then be preferable. Some of the things that the Law Commission or the body should look at in that situation would be conviction on particular forms of evidence, so the use of doc identification, the use of anonymous witnesses, for example, the use of hearsay evidence, also the majority jury verdict, also the power or lack of power of a judge to withdraw a case from the jury. There may well be others. In fact, I'm actually certain that's not a comprehensive list.
Does anyone else wish to comment? Professor Blackie.
They may want to look at, if you like, the educational side of it. And one of the things that is mooted is experts to assist in instructing juries on the dangers of eyewitness identification evidence. Now, there are problems with that, and currently the courts are not happy about it. But also police practice. For instance, in England, and the Police and Criminal Evidence Act codes of practice, the whole process of questioning suspects and other people is regulated in a much more regulated way than we have. Now, I'm not saying that's necessarily a good thing, but there's a big agenda there as well.
That's the Scottish Law Commission tied up for 5 years, I'm afraid, already.
Well, Lord Gill told us a year tops. Professor Wraith.
One of the difficulties that some people have alluded to in other papers is the way in which evidence is gathered or not gathered in some of the difficult cases for corroboration, and that's the sexual cases and the domestic abuse cases. And I know that the women's groups certainly feel that very often, especially when they've been working with women who have survived an attack of some sort, that there is a lot more evidence that could have been accessed or might still be capable of being accessed, but it's not always followed up. And that's very much a police practice, and it may not be something that you would want to explore, but I don't think we should ignore it, because if the evidence isn't gathered early on, then it's not there. One of the areas where I know this excellent practice, and I think everyone would subscribe to that, is in the SARCs, the Sexual Assault Referral Centres. There's one in Glasgow. There was to be one in Dundee, but I don't think it's got off the ground yet. And their method, through the clinical medical method of collecting evidence, first of all, makes the process of the medical examination much, much, much more conducive for women. They're more willing to consent to this happening. And there's a great deal of therapeutic process can go on with that at the same time, which it doesn't in the normal examination of the police station. So I think there are lots of small things that could make a difference. To the
and
way
also
that we
Victims and Witnesses Bill deals with gathering medical evidence,
yes,
and being able to determine which, the sex of the doctor that examines
yes,
you, so far as is practicable.
Yes.
Interesting. Does Professor Ferguson, do you want to say anything here? We've had little bits from everybody. You don't have to.
And I think the more we discuss this, it seems to me that what we're saying is that the consequences that we're hoping for are unlikely to be achieved. So in the sexual offence cases where it is the word of the complainer against the word of the accused, lack of corroboration, getting rid of corroboration is not going to help. But where I think it's going to be very dangerous are cases where you have confession evidence and fleeting glance eyewitness identification. These are notorious in every jurisdiction for miscarriages of justice. And it's very hard, if a witness is positive that that's the person who attacked me, it's very hard for a jury to ascertain whether they're correct or not. They may genuinely believe they're identifying the correct person, but they could well be mistaken. And things like the Innocent Project in the United States of America have found that that's a major, probably the major source of miscarriages of justice in that jurisdiction, is a witness being convinced they've pointed to the perpetrator, and in fact they've been shown later on to be quite wrong about that.
I was going to say, because perhaps you can assist the committee in in a general view of, you know, from the time of the crime to the time it comes to court, or the time where the crime and the time where the alleged victim identifies someone can be quite short, can be very long. And by the time they get to courts, it could be even longer. Is that, give us some idea of the difficulties in the timeline for if it's, accused identification? It can be quite substantial, can it not? I'm looking for help and I'm not getting
it. A criminal trial can take place, especially in the summary case, well over a year after the incident took place. And I think the committee can judge for itself how difficult it is to remember faces a year after the event. That's not something in which we can offer specialist assistance. I should say, by the way, I've had a second to go to evidence from Professors Ferguson and Rate. I meant from Ferguson and Davidson, just to be fair to Professor Davidson, who's not here.
Thank you.
Could I say there is?
Yes, sorry, Professor.
There is a lot of psychological work done, principally in America, but some of it in England, and there's some foreign language stuff as well, which has tried to structure these issues that we all feel intuitively. And broadly, they structure it that there are issues about perception in the first place, in one's witnessing, problems about remembering, that's the storing of the memories, and then problem about recall. And at each stage, there's a danger, if you like, of distortion. So it is common sense, but it is structured common sense. There is plenty of evidence for this. And the American literature, it's quite striking, the high levels of inaccuracy. I mean, as high as 40% in some cases after a year.
And it's compounded, I believe, in our jurisdiction because we allow doc identification, which many jurisdictions do not. Yeah. So it's perfectly possible for a witness to say to the police, I think I might know the person again in court, assuming that in a couple of weeks they'll be asked to point the finger. And then, as James has said, a year down the line, they're in court, they're giving evidence, and at the end, the prosecutor says, can you identify the person you've just spent the last hour and a half telling us about? There's huge pressure on that witness to look at the doc, look at the person in the doc and say, well, it must be him. And in fact, that definitely occurs. I mean, I used to be a prosecutor briefly, but 20 years ago, and I've certainly seen that firsthand. Witnesses who, when asked to identify the accused, will say, it's that person there, and point out the person that happens to be sitting in the dock.
Possibly they don't point the finger at the judge. That could be quite intriguing.
Usually with a bit more probing, you can get them to admit that the reason they're identifying.
Has it happened? It has. Excuse me a minute, this is it.
It happened to me. I was an advocate for a very brief period of time, donkeys years ago, and it happened.
What?
Was the judge convicted?
With the sheriff, no.
So they point to the judge, says identify, oh heavens. Was he acquitted? And by himself?
Yeah, the case fell apart. I was prosecuting in the sheriff court.
Sorry, yes.
Usually, obviously, with careful probing, you can get the witness to admit that the reason I'm pointing the finger at that particular individual is because they're sitting in the dock.
Yes.
But, if it's an unrepresented accused, it's very easy for that to just be taken as tick the box, you've got your identification, move on to the next witness.
I just say, John's absolutely right about the wealth of social psychological research on this, and he's absolutely right about the results, but I think what's striking about them is that our common sense would tell us that identifications 2 weeks, 3 weeks, 6 weeks, 3 months, a year later are bad. We know that. But actually, it's much worse than our common sense would indicate. That's what the research indicates. It's much worse than just a common sense approach would indicate. We're much less reliable than even we think. If we think about it sceptically and objectively, it's still much worse than that. And I think that's what's often not realised.
Well,
when we sit as juries or judges as fact finders, we come from an over-optimistic view about that.
I've got a bit distracted with your story, I have to admit, about the judge being identified, but I will not identify the judge, I don't think. It wouldn't be appropriate. That was interesting. A slight diversion, I think, for us. But Margaret, Sandra and Roderick, let's move. Margaret.
Good morning, panel. It seems to me the motivation for this change and proposed change is to address the low conviction rates with certain interpersonal crimes, sexual assaults and rape, on the assertion that corroboration is the barrier. Now, we've already heard from Professor Chalmers that that doesn't explain why the cases that have passed the threshold for corroboration still aren't resulting in convictions. So it seems to me, therefore, we should be looking at more court practice. And here, Professor Ray, I was quite interested in, for example, in rape and serious assaults, your suggestion that the complainer should have some legal advice, because the women's groups have told us there is a problem sometimes with juries and an inbuilt prejudice sometimes in juries that has to be overcome. Now, in this financial climate, the prospect of that is absolutely nil. But we do have, as the convener has already said, a witnesses and victims bill coming in, where there's an amendment going hopefully forward at stage 3. In fact, is tabled at phase 3.
Is this a trail?
Yes, it is.
Is it your amendment?
Yes, it is.
Oh, well, there's a surprise.
Where rape victims would be given legal advice as to whether or not they should give permission for their medical records to be used, and if so, to be a bit more careful about exactly what they're giving permission for, because very often the whole medical record, totally irrelevant things, are accessed and then brought up in court to discredit the complainer. Would that be something that might help the conviction rates? And it could be done in a pilot relatively cheaply and put in place pretty soon.
I think she's actually looking, and you know what you're being asked to do. Yes, it's written all over your face, is to give her a supporting quote where she puts forward an amendment. But I think we are looking, if we can broaden it a little, into court process and court procedures.
Yes. Well, I won't comment on the specific.
I knew you would.
Model that you suggested, though I have to say I have in fact written about a possible model, so they do exist, but they're built on the type of models that are available in the continent, and also, most importantly, available in other adversarial jurisdictions. So Ireland, Canada, the two main ones, I suppose England to some extent, because they have piloted voluntary sexual advisors, and in fact I think our own Rape Crisis is trying to do the same, but they're not obviously legally qualified, and the big distinction is whether women, knowing their rights in relation to access to their medical and sensitive records, and indeed in relation to sexual history evidence, knowing their rights rather than having to assume that the Crown will defend their privacy rights, that would put women, it is thought, in a much stronger position in terms of the evidence that they then are able to give when they inevitably will be cross-examined on either what's in their medical records or on the facts of the case that's been prosecuted. And the evidence shows from large studies that have been done mostly with the European countries that women certainly felt a lot more confident and more willing to discuss intimate and very difficult matters in court if there was someone there who they knew had been supporting them through, who would object when anything inappropriate was mooted. And the difficulty is that we always hear that judges have a role to intervene when witnesses are being pushed and being, as they feel, given a really hard time. But judges are very reluctant to intervene. And there is a study that I did some time ago with judges. When I asked that question, they all said, well, you have to be very, very careful not to intervene, because it could lead to an appeal. So they're put in a very difficult position. And without that, you've only got the Crown trying to do all the things they have to do, ensure a fair trial, look after the rights of the accused, prosecute in the public interest, and also somewhere look after the complainer's rights. So I actually think we have a problematic position in terms of the Human Rights Act if we don't recognise that women may need independent advice in the very particular situation of a rape case where the focus is on them and become more so if corroboration goes. Juries tend to find it difficult to believe or to know what to do in a he said, she said situation. Yes. And so independent advice could help.
And we'll switch to Professor Duff.
Yeah, I mean, I think you're right. We do have to look at the broader court procedures. And, I mean, just two very brief points. We know that the conviction rate for rape trials in other jurisdictions without corroboration is similarly bad. So it's nothing to do with corroboration. It's about court procedures. And again, there's a lot of comparative research could be done by looking at what's done elsewhere. I mean, I'm aware of the cost, but actually, if I recall, the number of rape trials last year in Scotland was under 100. So it's not, okay, it is a cost, but it's not a huge cost if you restricted this legal representation, as Fiona Rates argued elsewhere. just to rape trials.
2011-12 is 75.
75. Okay, so you've got an advocate or a solicitor representing the woman complainer in 75 trials. That is a cost, but it's not a huge cost.
Yeah. And it would be the whole trial if you follow models from other countries.
Anybody else wish to comment? Nope. Margaret? Good try.
Given the, well, there isn't necessarily the complexity of it. Can I first address this sufficiency and this stuff that's been going around about quality of evidence, which I think is a total red herring. I mean, quality evidence and sufficient. The more evidence you've got, surely that would only help prove the case. So given there's been such confusion, not least last week, where we had the depressing evidence from the police, is there a case, and is it all of your view, that this should be taken out of the Criminal Justice Bill and the whole issue looked at either by a Law Commission or a Royal Commission, which I think could probably have a panel of experts look at it in depth and deliver some findings perhaps faster than a full-blown Law Commission?
Yes.
Yeah, absolutely. Thank you for that.
There's a chorus there. Well, it's Christmas after all. Right, but not in song. Now, can I move on to Sandra, followed by Roderick, please?
Thank you very much, Convener, and good morning. It's still
slow to come waking up,
I've
John. Supplementary to that.
Yes, indeed, very specifically to that,
right.
if I may, panel. In the policy memorandum, which maybe the layperson would be more inclined to go to, Policy Objective 130, the policy objective is to remove the requirement for corroboration in criminal cases. It's a very clear statement the government make. They also, in relation to this particular issue that my colleague Margaret Mitchell's raised there, say the Scottish Government considers that Lord Carloway's recommendations, this is specifically in the passage on corroboration, recommendations are intended to be implemented as a coherent package, and failing to implement a significant aspect of the recommendations contained in this report, and this is referring to corroboration, there's a very real risk of undermining Lord Carloway's stated aim of ensuring the justice system is appropriately balanced. Now, you don't...
You're on camera, Mr Duff, and you're grinning, so you better answer that one.
So the recommendation of this particular aspect to the Law Commission puts the rest of the legislation in jeopardy, would be my reading of that. Would you have a view on that at all, please?
Mr Duff.
Absolutely not. I mean, the main... I mean, it's only one substantive section and two other little sections. The main thrust of the Carloway report and the main thrust of the bill is to cope with cadre and new arrest procedures, new representation, police station procedures and so on. That stands alone. The removal of corroboration makes no difference to the rest of the bill, in my view.
The rest of you were quite happy then, the rest of the review panel, having your disclosure that many wanted corroboration with the Law Commission, but with the other issues in here, were the most of the happy?
There was more or less general agreement on the rest of the package, yes.
Thank you. Yes, Professor Chalmers.
I'd add, not only do I not believe that, I don't believe the Scottish Government believes it either. There are other recommendations...
Sorry, just take that past me again. I don't believe that you don't believe that I don't believe. I was one of those...
yes, exactly.
You actually don't believe.
The Scottish Government has not taken forward all the evidential recommendations in Lord Carloway's review. Lord Carloway made specific recommendations on the admissibility of confession evidence that the Government decided could be left out of the Criminal Justice Scotland Bill without destroying the coherent package, which is referred to. So the suggestion that the corroboration requirement cannot be taken out because it's all or nothing is not one, again, the committee should be persuaded by.
I followed that.
Change is also not in the package as I originally understood it either, so the package is a movable feast, to make some metaphors.
A package that's a movable feast. It doesn't displace the judge that was pointed at as that's my moment of the day. Can you identify the accused? And it was the judge. I wish I'd been there. But you were the defence at the time, I take it, so you wouldn't be very happy. Anyway, back to business. I've digressed. Sandra, followed by Roderick.
Thank you, Convener, and good morning, panel. If I could perhaps just go over some of the issues and probably clarification for myself to establish where we are at the moment. First of all, I think we've established that we're talking about in abolishing the corroboration per se. It's not about that. It's about the mandatory requirement for corroboration. I think we've established that, and that's actually come from last week's evidence that the convener actually said we're not talking about abolishing corroboration, but about the mandatory requirement for corroboration. So that's, convener said that, so I'm taking absolutely certain
it's gone. That's, we're all clear as
a just last week.
Bell about that.
The second point, I think we all seem to agree with, and I'm quoting from Professor Dove, which mentions the fact about the corroboration requirement being so watered down over the years, principally by judges. And you've already stated yourself that it's not nearly as strong a safeguard against wrongful convictions as was previously claimed. And you mentioned this word, and I'm quoting from you, so it's not me to say it. Additionally, the fiddles you mentioned, the fiddles that judges have created to get around corroboration have led to a confusing, illogical and inconsistent set of evidentiary rules which practitioners, including judges themselves, often have great difficulty in applying. So I just mentioned that. Now I come on to the bit where I'd like to ask you the questions. If that is absolutely true, and we also think Professor Ferguson mentioned the fact about sort of a tick the box when it comes to basically doc identification as well, why is it that corroboration as it stands at the moment is so important and the be-all and end-all when it's not in other jurisdictions? And I know they have other safeguards also, but why is it that academics like yourselves, judges, etc., say we cannot get rid of corroboration where victims, people who have miscarriages of justice, as Professor Blackie has mentioned, as well as accused, why is it that there's this big difference between the academics, the judges, the lawyers and the victims who feel that 3,000 cases of domestic abuse, rape, etc. are not being heard because they do not meet that specific requirement? So if you could maybe give me your answers to that one.
Seeing you quoted from me, yes, I mean, I'm not, as I said, I'm on the fence about corroboration. It is no longer, or it is not the sort of absolute guarantee against miscarriages of justice that it is often thought to be, because the judges have been, as it were, forced to water it down in order to, secure or open the door to convictions where they think it's necessary. But it still has some value. It still has some value in in preventing miscarriages of justice. And I'm not against getting rid of it. I mean, some of my colleagues may be, but I just think if we get rid of it, it is an important part of the Scottish criminal justice process. I'll avoid the word package, and the collection of protections that are there for the accused. Now, if you are going to get rid of it, which, as I said, I'm quite open to, I think you have to think more holistically, as John Blackie said, about what other protections you might need to put in place and look at other systems that don't have corroboration, and see, where to draw the balance between the rights of the victims, to expect a prosecution where they've been the victim of offence, and the rights of the accused, and in fact the rights of all of us not to be convicted wrongfully of a crime we didn't commit. And that's really all I'm saying, is that one's got to look at this, have a proper look at this. And, we're not convinced, I think we're saying, that the Carloway review looked at this in the round, as it were.
Okay, thank you.
Yes, Professor Chalmers.
I'm not sure any of us would say, although I don't want to put words in my colleague's mouth, that a criminal justice system requires corroboration. Clearly not. There are many systems around the world, most systems that do not use corroboration. But where you have a system that has built its system of protecting people against wrongful conviction around the corroboration requirement, you cannot simply withdraw that requirement and put nothing in its place, because that's the foundation of the system that we have built up over the years. And I appreciate the concerns of victims not having cases brought to court, but it is in no one's interest, victims or otherwise, to have a system which wrongfully convicts people of crimes of which they are not guilty.
Anyone else wish to comment? No?
Yes,
Professor.
Sorry, I mean, I think we were talking earlier about the conviction rate in sexual offence cases, but the bigger social problem, I think, is not the conviction rate, but actually we know that there are many, 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 many more sexual offences which don't go to court. But if it's thought that by abolishing the corroboration requirement that's going to change, it's not, in my view. And there are other matters that probably we ought to be looking at urgently with regard to that whole field, because, yes, it is deplorable. It is deplorable. And I would be very worried if this was seen as a way of a quick fix, which it isn't, to what is a serious social and justice problem.
Yes, of course, a follow-up question, and thank you very much for your comments. And yes, you mentioned about wrongful conviction, but obviously victims feel as though they're not, basically, you know, it's wrongful for them as well, if they're victims, that they don't meet this criteria. But you mentioned safeguards, and absolutely, and obviously we've been looking at the safeguards, and you mentioned a number of them, the jury size, etc., and distress. Have any of yourselves as academics been asked to give an idea of what safeguards you would like to see by the government or by the Law Society or anyone else? Have you ever been asked to put forward your ideas about safeguards?
I think, you know, we've been asked here to give our some ideas.
I actually asked for a remit.
I was on the Carloway expert reference group, as I said, and one of the reasons I was there, along with many others, was to talk about this issue. But following up Professor Blackie's point, yes, you know, there is the other side of the coin. You know, we're perhaps focused unduly on wrongful convictions. But I mean, and again, we talked about this earlier. The problem is, if there are a lot more prosecutions that fail, we don't know what the impact on those victims will be. I mean, they may be very disappointed. They may go through this terrible ordeal, which we all appreciate court can be for them, and the removal of corroboration does nothing about that, as we've seen. They may go through this terrible ordeal and end up with an acquittal, which they will see possibly as a slap in the face, a jury not believing them, which will actually make their situation worse. So, I mean, one of the problems is if you get an increase in prosecutions, which clearly the Crown wants, then you may get an increase in acquittals and more unhappiness on the part of victims. So rather than resolving the problem with the quick fix, the government will actually have succeeded in making the problem worse.
Yeah, but just to come back in that one, I don't think I have a right to tell a victim that they cannot be heard in court and it cannot go forward. And I can't see into the future in regards to whether some victims may feel better and others may feel worse. So I don't think we should make the absolute assumption that every victim, if there's an acquittal, is going to feel bad about it. I think we should perhaps look at some of the positive sides of it. I know that when Rape Crisis Scotland and others had been mentioned, and yes, some of them said that it might be worse for them, but then again, some have said they actually feel better as well. So I think we should get that one, you know, right, that it's not always a negative aspect. Sometimes it's a good aspect, a positive aspect, that people can go to court and they feel as though they've been able to tell their story. Maybe they're not believed, but at least they feel as though justice is done at some extent for the victims as well. I think that was just a statement, sorry, rather than a question.
You know, we don't know. We don't know.
So I think we should get that on record.
I'm going to move on because I think we've aired that thoroughly. We've got Roderick, you're next.
Morning, panel. I'd just like to begin by just looking at the new prosecutorial test and inviting your comments on that, and also really your comments on the Lord Advocate's evidence that he gave on the 20th of November in relation to the Crown's approach to evidence generally and to the need for there to be some kind of supporting evidence before reaching a view as to whether there was a reasonable prospect of conviction. Anyone want to start on that?
Professor Chalmers.
I think the test that's been outlined in the Crown Office evidence is a sensible test. It's probably the only test that I think could have been put forward in the absence of corroboration. It's consistent with what happens south of the border in England, where corroboration is not required. It would be wrong to suggest that that test offers any additional safeguard of any sort. It simply asks the question that the prosecution would have to ask in the absence of a corroboration requirement. On the suggestion that there must be supporting evidence, I do not understand a position that says we don't think there should be a requirement for supporting evidence, but we're not going to prosecute without it. That to me is incoherent.
Incoherent, well, that's a wonderful word. Anybody else wish to comment?
No, I mean, I would agree entirely with that, because I think, as people have objected to the removal of corroboration without sufficient thought, I think those in favour of it have kept changing their arguments, and they end up in these very inconsistent positions. As we said, we're not clear what the difference between corroboration and supporting evidence is anyway. So we don't need corroboration, but we do need supporting evidence. Well, what is that supporting evidence? It's corroboration by any other name, which is the position in most other jurisdictions. So, yes, it's incoherent.
Okay. But perhaps we can move on to the question of summary cases, which obviously are the greater number of criminal cases. The bill, as drafted, makes no provision for any additional safeguards, for want of a better word, in relation to summary cases if the mandatory requirement for corroboration is removed. Any comments on the position of summary cases in particular?
Yes. There might be an argument for saying if you're going to abolish corroboration, summary cases are the cases to do it in, since the stakes are less high. Although they form the bulk of the work of the courts. I think it's more worrisome that somebody could be convicted under solemn procedure of a very serious offence without corroborated evidence. So, again, that's something a law commission or an expert body could look at, is are there arguments for saying that there are some crimes or some forms of evidence that need corroboration, a more nuanced approach rather than simply saying let's abolish it across the board.
I think also the stakes are less high, as Pamela says, in summary cases. But of course, in summary cases, the decision as to guilt or innocence is being made by a sheriff who is an experienced lawyer, and we assume, perhaps without justification, but we assume that they are more able to realise that witnesses may come over as credible but are not. They will be more aware of the failures in witness testimony. I actually think that probably is the case. That they will be more aware of the dangers, and therefore the real danger is that a jury will be taken in, as it were, by one very plausible witness who presents well in court, who is simply not telling the truth. A sheriff is less likely to be taken in by that sort of witness.
Yes, Professor Blackie next. Yes.
Two things about summary cases. Of course, they're not all done by sheriffs. Some of them are done by justices of the peace. And there are questions maybe you would look at, perhaps having 3 justices or something like that. The other thing is about resources in small cases. It is mentioned in Carloway that the police don't devote a lot of resources to getting corroboration in summary cases. For the very obvious reason, there are a huge number of them, as you say. And so, yes, that might again be an argument for having differences for summary cases.
A number of sheriffs have said anecdotally, I think one has gone into print with an example, that they have heard cases in summary procedure where they've heard a single witness who they have found persuasive and convincing and would be prepared to convict on that evidence. And it's only when the second witness has given the evidence that they've realised just how shaky and unreliable the prosecution case is, and in fact that the standard of proof beyond reasonable doubt has not been met. Now, I would be surprised if, in a situation where corroboration were abolished, the Crown continued to call that second shaky witness.
Just moving on, I'm conscious of the time, so I'll just move on to the question of the Royal Scottish Law Commission. Professor Ray, I was taking the opportunity recently to review my book collection, and I came across your excellent book on evidence. Was it a 1990s edition, where you referred to the background to the abolition of corroboration for civil cases and to the fact that there was, I think, a 1965 Scottish Law Commission report which recommended the abolition of corroboration across the board for civil cases. But there was a political row, so it led to the abolition in 1968 of corroboration only in personal injury cases. So from that, can we deduce that reference to Scottish Law Commission in itself is not necessarily the answer to all our problems?
I suppose that must be true, and the Law Commission compositions will change, and I suppose and most people have quite firm views one way or another about corroboration. I think, Bob, perhaps Pete, you and I are perhaps different, because I too feel I'm pretty much on the fence. And insofar as one's corroboration, if it is abolished, I don't actually think a great deal will change. Now, I may be completely wrong on that, but I think that the pool of relying upon familiar culture is what will mean that I don't think we'll see a great deal of change. But I may be wrong. Let's not put any money on it. But to answer your question a bit more fully, the Law Commission, I think, would welcome this being referred to them. I think I'm sure they must feel it was was going to say absurd, but it was extraordinary that their report on similar fact evidence and the Moore Doctrine came out just at the time when the Carnaby report came out, and the idea that the two hadn't really been speaking to each other because of events, I suppose, it just made that particular very, very important Law Commission report, it seemed to me it got buried in terms of the media attention it got and the attention in the literature, actually. So a referral back so that it could be opened up in a wider context would seem to me a much more sensible way forward.
Yes, Professor Mackey.
I recently read the Hansard debates behind that early legislation. Two things. Things have changed a great deal. One is it was the very first ever piece of work by the Scottish Law Commission. What they did in their preliminary work, the memorandum as we called in those days, is that they recommended for personal injury. Then in the report, which was extremely brief, they suddenly changed it to everything. Now, of course, when it was introduced in the House of Lords, and it was Lord Reid, who was a Scottish judge in the House of Lords, but of course they were political in those days, and basically it was ripped apart because of that, because all the research had been done for personal injury, and nothing but nothing. So honestly, I don't think it's a good guide to what would happen today.
The interesting thing is that to get rid of corroboration in civil cases, it was thought appropriate that that should be something to refer to the Law Commission for due consideration. And I think at the time it's always been accepted that corroboration in criminal cases is more important. That's why it's remained. So it seems strange that where it is of less importance, it goes to the Scottish Law Commission for full consideration. Where it is of more importance, it doesn't.
Just like to wrap up generally, we've touched on the question of safeguards a couple of times this morning, but no one's really been drawn. Is that because, as far as the bill is concerned, you simply feel it's misconceived? Why is it you will not be drawn on the question of what safeguards could be there to improve the bill?
Well, for my own part, I don't think that is something which could be adequately dealt with during the passage of the bill. It's actually a very complex question that would require extensive comparative research. And while I think that could be done quite quickly, I don't agree with Professor Duff that it would tie up the Law Commission for 5 years. I don't think it's something that
Are you
can
being
be done by
frivolous,
way of
Professor Duff?
I was being frivolous.
So can you amend it? How long do you think it could be done in?
that comment, Jess.
A year? Are we talking? It's a serious point. If one was considering something.
Well, I think how long did similar facts and previous convictions? That was a couple of years. Yeah, I think a couple of years is a more realistic timetable.
Okay, right. Would you agree that that's something like that?
I think it possibly could be done a little quicker than that, but that depends on the Law Commission's other commitments, and I don't have any information about that.
One thing, if I might say quickly, that struck me when looking at the options on safeguards is that's when you have to, you will see unravelling the interconnectedness of the rules of evidence, because hearsay evidence, for example, might become more important as part of the supporting evidence, and that could be a disaster. And hearsay evidence, the rules there are even worse than corroboration.
Yes, I seem to remember doing essays on hearsay way back in the mists of legal time. Have you? I think, in fairness, because we've got Michael McMahon next with his members' bill, and I know this isn't at the tail end of it, and don't look at the clock, we can't look at the clock. If you could possibly, and you feel you might, give us the advantages and disadvantages of the three-verdict system, and whether abolition of the not proven verdict should be considered, and if so, the most appropriate time and route for doing so. And I know the government's considering referring that to the Law Commission. So if you could just kind of give us a kind of bit about that before we have the member in who's going to talk about his proposed bill. Who would like to comment on the three-verdict system, and should we get rid of not proven, or what should we do with it, and blah, you know?
Well, I mean,
Professor Duff, you go into the fray. You're a man that goes into the fray, yes.
I've written about it in the past and said it should be abolished, and it's been considered at least twice before in the last 20 years. And for reasons that aren't clear, it's been kept. Probably, I think, just a sort of historical fondness for the fact it's very different. I mean, the presumption of innocence to me leaves no room for it. You have your trial, you're either found guilty, or if you're not found guilty, the presumption of innocence means you must be found not guilty. There's no room for a kind of second-class acquittal where, well, we're finding you not guilty, but we'll leave you with a bit of, bad press hanging around your name.
So what should be the route for doing it? Was the
I
second
think
part.
I'd be quite happy for it to stay in the bill, though it's come in by complete accident, but it's been considered often enough before. I don't think it's important enough to need to go to the Scottish Law Commission, quite frankly.
I don't think it's in the bill.
Is it not in the bill along with the...
It's not in the bill.
Oh, I'm
it's
wrong
a
then.
member's bill. It's a standalone member's
Michael
bill.
McMahon's bill, right, OK, I thought it had been put into the bill
No, it's
along
not
with
the criminal
the
justice
change to the majority verdict, so it's a separate matter. No,
no.
I would just treat it as an issue on its own merits then.
I agree. I don't think it needs to go to the Law Commission, but I think it should be abolished. The biggest problem with it is, of course, that jurors aren't particularly told by judges what it means. And when you talk to students, first-year students, about what the not proven verdict means, quite a number of them assume that it means that the Crown have not established the case beyond a reasonable doubt on this occasion, so it's a kind of a hung trial. This jury couldn't make up its mind, but we can have another bite at the cherry. And that, of course, is quite wrong. And people don't appreciate that it's the same as a not guilty verdict. It's a historical anachronism, and we should get rid of it.
What I'm asking you is in consideration, if it was in this bill or absorbed into this or whatever, with the impact of if we abolish the requirement for corroboration and at the same time the not proven verdict, is that one of the other things in the mix? You know, or could it just be done?
I think it could be done. The two are unrelated in my view.
That's fine, it's just I'm asking. Professor Raitt?
I would agree. I think it should go. It doesn't add anything.
If juries are doing what they're asked to do, and we have to assume they are, or we have other serious problems, then they have to consider whether the case has been proven beyond a reasonable doubt and they convict. If not, they acquit. And then there's a question of what acquittal they reach. So on that basis, abolishing not proven would make no difference whatsoever. I agree that there's absolutely no reason for it to go to the Law Commission, and I can't see any rational reason for retaining it.
I think another reason is that the proportion of acquittals which are non-proven verdicts, I think, is around about 10% of acquittals, so it's not very common. Historically, it might have been better that we had two verdicts. One was proven and the other not proven, so without emotionally loaded language. And the reason for the not proven, that is what it was before the middle of the 18th century.
In rape cases?
In rape cases, it's higher than in others. That
20%?
is correct. Yes, rape cases are, it's interesting, they're out of line, and that says something,
Yes.
obviously. So, in my ideal world, we would have two verdicts, and they would be proven and not proven, without emotive language attached to them. It came about by historical accident. This has been well charted. In the middle of the 18th century, a jury asked if they could follow the English approach and bring in a verdict of not guilty. So it is anachronistic. And particularly, perhaps one should say that now that we've abolished the double jeopardy rule, so there can be trials again later on, that is a further reason.
Well, thank you very much. I'm glad that we managed to get that in time for Michael can hear that when he comes in. And I suspend for a 5-minute break. Thank you very much, panel. Thank you. Thank you very much. We resume, and I welcome Michael McMahon, MSP, as members know, has lodged a members' bill on criminal verdicts, and we'll give separate scrutiny to Michael McMahon's bill at a later date. However, there is some crossover, as we know, between his bill and the Criminal Justice Bill, and so it would be useful to hear your views on that, Michael. And also, perhaps if you just tell us, I haven't actually seen how many parts to your bill there are, so if you maybe just explain what your bill does to start with. And then, you know that the previous panel endorsed abolishing it, so there you are. You start from a very good position.
I do welcome that support, Convener. It's in line with the support I received for the bill in general. The bill is actually a very simple one. It's in two parts, and it's only over a page and a half. It's not going to be the most technically demanding piece of legislation that any committee, I think, is ever going to look at. The first part is effectively to remove one of the acquittal verdicts, and the second is to change the size of the majority in juries. And the responses that I received related to that, some commented that there was no correlation between removal of the second acquittal and juries. Others argued that it was important to take into regard any changes in that for a variety of reasons, and I'd be happy to try and explore them if you want to fire questions at me on it.
Yes. Questions? Yes, John, then Elaine, please.
Mr. McMahon, is public perception an important part of your motivation for this? I mean, I share your view.
It is, Mr. Finney. I mean, the reality of the situation is we need to have confidence in our judicial system, and I believe that the third verdict creates confusion, and it's illogical. We have a verdict which, sheriffs in our courts are not allowed to explain to the jury what it means, and in fact, when they have done, it has led to action being taken against those sheriffs and the cases being reviewed. So we have a system here which is only in common law, it's not in statute, but that common law creates confusion. So that's the reason that I think we have to get clarity into the system so that people can have confidence. And I think which is why the second aspect of the bill is vitally important, that people can have confidence that a jury has considered the evidence and found one way or another beyond a reasonable doubt. And I think a simple majority leaves that question. You can have very serious cases being concluded one way or another on a straight majority, and I think we need to have a look at that, and the responses that I got to my consultation made that point.
Do you have a view, Mr. McMahon, what the new verdicts, the two verdicts, would be? How would they be styled? I don't know if you heard Professor Blackie, for instance.
I didn't actually. One of the things in my consultation was to make the point that the original Scots verdicts were proven and not proven. It was actually the not guilty that was added. As I said, it's become custom and practice. It's only common law, common usage that allows Scotland to have these three verdicts. So we have a system which is there by dint of history rather than by any considered decision. So I think we have to bear that in mind. It was not designed to be this way, and I think that's where part of the confusion arises in relation to it. So in respect of the majorities, the two verdicts, we start from a position where Scots law had proven and not proven. Not guilty was added. Then guilty became the verdict rather than proven. And just, as I said, it's just over a period of about 400 years that we have developed this system and arrived where we are. It was not designed this way. It's where we are and what we have. But I think we need to look at it. So in my consultation, I made the point that we could revert back to our original verdicts, or, given that not proven has become so controversial, that we just move away from that altogether and just revert to a guilty and not guilty outcome. Most people preferred that, but I'm still open to persuasion as to whether, if we want to have a very distinct Scots legal system, that we shouldn't have proven and not proven. But I think the danger in that is that the confusion over what not proven would carry over into that. So a clean break might be better.
Finally, if I may, just one question. Continually, Ms McMahon, when we've looked at the issue of juries, we're told about the lack of research and clearly the integrity of the jury and the ability. Is that something you've come up against as well in relation to you?
It's very difficult. A number of people who responded to my consultation, I couldn't use their responses because they're not allowed to comment on what happened inside the jury. So we have academics commenting on what they know and have built up experience around, but actual responses, although I could give you many anecdotes that have been given to me about people's experiences of serving on a jury.
Not allowed.
Exactly, I'm not allowed to do it, so it is purely anecdotal, and it's not included in my consultation findings for that reason.
No.
Thank you very much.
Thank you, Convener. Section 2 of your bill is actually pretty much identical to Section 70 of the Criminal Justice Bill, and that's the bit about changing the jury verdicts. And the reason that that's in the Criminal Justice Bill is actually partly as a safeguard in case the requirement for corroboration is removed. You feel that there's actually a separate argument in relation to your particular proposals in terms of the jury verdicts, which would require this sort of change anyway, even if we referred back the abolition of the requirement for corroboration.
I consulted in relation to the removal of the third verdict, and people who responded were looking at the juries in relation to that. I think there was only 1 or 2 academics who responded and said, both in terms of the third verdict and corroboration, we should look at the juries. Most people focused on the third verdict and juries. And there was one academic who said that regardless of whether we change corroboration or the third verdict, we should look at juries anyway because of this straight majority, which raises questions about whether a case has been tried and found the conclusion arrived at, beyond a reasonable doubt.
There would seem to be a suggestion from the panel earlier that the non-proven verdict was being referred to the Law Commission for consideration. Have they had any discussions with the government about that?
I think this is something that's reviewed periodically. My experience is that they've always concluded that it should not be addressed. And again, even in the consultations we've had, the Commission set up now, Carloway and others, by the Scottish Government. And the not proven verdict has never been looked at in terms of addressing it. So while it's always a matter for conjecture and discussion, it's never actually moved forward to being looked at by a formal commission or by the Scottish Government in any of its consultations. The legislation that you're looking at the moment didn't refer to it at all, but looked at the verdicts, which, as I said, some people have made the connection between the two.
I think what I'm looking at is that in the response to the Scottish Government's consultation about whether the not proven verdict should be abolished, it says a significant minority of respondents were concerned that time should be given to allow the impact of implementing Lord Carloway's recommendations to be assessed before making changes to the three-verdict system. Now, we're in a position where we might end up with a criminal justice bill that contains the abolition of corroboration with a change to the juries, or we may not end up with that. We may end up with one that takes that out, takes corroboration out, and possibly takes out the jury size as well. So it kind of clutters what you're doing in a way. If you see what I'm saying, I don't know how we can disentangle, very sympathetic to your position, but I don't know how we can disentangle this from what's been put into the criminal justice bill, which apparently, in the evidence we've had, didn't have a lot of research into why it's 1510. It just sort of came about. I'm not saying yours just came about, but it just came about. So I'm wondering about how you reconcile, if it had just been the not proven verdict going on its Todd, as it were, and not touching juries. I think the jury issues would be difficult for me.
I consulted twice on this proposal, and the first occasion didn't focus much on the juries. It was because of the information I got back that I decided to have a second consultation.
Yes.
Because the jury aspect of it could not be disentangled, or I felt that we needed to certainly consider it much more thoroughly than had been the case, because the original consultation was purely about the removal of the third verdict, and the issue of juries became very much a prominent feature of the responses that I got back. So I took stock of that and had a further consultation, which looked at bringing forward a bill in 2 parts, very specifically because of those issues. I have been aware of the legislation that the government has brought forward on previous occasions, and waited on them doing some work around the not proven. I felt it was time to move the thing forward, and that means having to have the issue of the juries addressed. Now,
no, I appreciate that.
We just have to wait and see the outcome of this, the legislation that you're scrutinising at the moment, to see whether it has any impact, whether taking the part 1 of my bill into the criminal justice system could be a consideration, depending on the findings that your committee has, convener, or whether the government thinks that the consultation has been sufficient to allow it to incorporate my proposal on the third verdict as we move forward.
I'll take Sandra now, please.
Thank you very much, convener. And it's still morning. Good morning, Michael. Very supportive of the context of your proposed bill, and certainly learned some interesting historical facts from Professor Blackie and yourself also, that it was proven, not proven, until we took over the English law 400 years ago of guilty or not guilty. And funnily enough, I did say perhaps we should just go back to the proven, not proven, as you had mentioned yourself as well. I think it's something we might have a wee look at in that respect. When we were talking about the juries, and obviously you went back out to consultation again, was that in the suggestion that was part of a safeguard if you got rid of the not proven verdict?
Some people have suggested that that is something that would be considered as a safeguard, because if you remove the third verdict and still left the simple majority, that would be of concern to a number of people. That was highlighted quite clearly, Sandra. So yeah, it was pretty much in response to those kind of questions being posed around the first consultation.
Could I just a wee follow-up question?
Yes.
Yes. Thank you. In regards to, obviously, the government has said that they're supportive and perhaps would go to the Law Commission. Can you give us a timescale you would like to see your bill being put through? Do you think if it went to the Law Commission it might make it longer to go through? Or just your thoughts
It may
on
well take it long. It may well take longer, but I'm in your hands anyway, convener, because it depends on your work programme whether you could fit in my legislation anyway. So I'm certainly open to a discussion about how quickly my legislation could come forward, whether it would have to wait on a law commission. Investigation again would be something worth considering. I just feel, we've been here for 14 years now. We've looked at an awful lot of legislation. This is one of the most controversial areas of the judicial system. And
not quite.
It's one of the most controversial aspects of the Scottish judicial system, and we've never looked at it. And I feel that we certainly, one way or another, have to address the issue of the not proven verdict.
Just a point of clarification there. I may have overset my mark, I don't know, but I just want to clarify. I just want to clarify that the government has indicated that it's agreed in principle with the Scottish Law Commission that a review should be carried forward. I just wanted to clarify that.
I think I said that, but I know nobody
No,
listens to me, so I don't take it personally.
No, I think for Mike.
I was aware that was under consideration. Yeah.
I think the issues you'll understand is that the second part, which if your bill were to progress as standalone would have jury verdicts changing. We've got something else in another piece of legislation. So maybe the committee wants to consider this when we review our work programme and how we look at the way forward. I think that's the main issue for us, is the issues that you'd appreciate that in one bill we've got juries, in this bill we've got juries, and that's an area we're still exploring under the Criminal Justice Bill. Yeah. But you had good support, as you know. And do feel free to come in next time, to the committee.
Didn't want to overstep the mark.
Oh, no, we're very relaxed in here, too relaxed sometimes. Can I thank you very much anyway for that? It's very helpful. Thank you. And we're going to move on now. We're going to move on to item 4, which is consideration of Criminal Legal Aid Scotland Fees Amendment Regulations 2013, SSI 2013-320, which we looked at last week, and agreed to write the Scottish Government seeking its response to concerns raised by the Law Society. We now have that response, and it's with your papers. Do you want to comment on the instrument or the response? a rattle of papers, a rustle of papers as we gather ourselves to the next bit. There's nobody's putting a negative. What's the procedure? So there should just be comments. Can I just give you some guidance on process? Any further consideration would have to be taken next week, or we can note the comments on the record that we do just now. When's that going to be launched? Yes, nobody's lodged a negative instrument, so if you want to do anything, it'd have to be a motion to annul, and we could invite next week if we needed. Yes, one of the opportunities was to invite the Cabinet Secretary to give evidence next week, you know, on the responses that we've had, the interaction between the Government's position and the Law Society of Scotland's position. So let's just have your comments first of all, if you want to.
I don't think that the letter from the Cabinet Secretary properly addresses all the points that the Law Society have made about Rob and Peter to pay Paul, really, is what's going on here. And I am minded to lodge a motion to annul.
Yes? Any other comments?
There seems to be some, well, from the Law Society, they're saying that it does address the cost of these new provisions. But I think they've got a concern that this becomes a precedent, convener. So, and I also see that the Cabinet Secretary or the Government is saying that the amount of money isn't reduced in total, it's maybe just allocated in a different way. Could we have some more, maybe, advice on that?
Do you want a further response from the Government? Did the letter from the Government come in after the letter from the Law Society or before it? Simultaneously? So it's responded to. We've already had that. Sandra?
To raise a couple of things similar to what Margaret was saying, though I think they're a wee bit clearer for me. I don't know if we need more information. It mentions on page 12 of the letter, well, page 12 of our papers, which is the second page of the letter, it says the current system is a hybrid of inclusive fees and detailed fees, which was developed with the Law Society's full involvement. And then it goes on to mention the fact that solicitors are being paid the same amount of fees overall, but in different, more transparent ways, which seems to answer the questions that the Law Society obviously differs in what they are saying. But for me, it answers that the Law Society lawyers are getting paid for their work. It's just in a different way that it's being looked at, but they're still getting the same amount of monies. What I can see here.
Anybody else comments? Aileen.
What the consequences, if we moved to annul the amendment, what the consequences of that are going to be? Is it going to leave us open to ECHR challenge?
That's for the Cabinet Secretary to respond to, and I take it if the motion held, it would be a debate in Parliament about it. Debate here, debate in committee, beg your pardon. Debate in committee. Roderick.
Just wondering on this ECHR assessment point, the Law Society urged the committee to undertake a full ECHR assessment. What are the implications of that? Really aiming that at the clerk.
Can I suggest that we, I hear about your motion, and I think this is something I'd like to discuss, and can we discuss this in our work programme? Can I defer this so we can involve the clerks and the routes forward into our work programme today? Just move on to it then, so you get all the options discussed, because I can't bring them in publicly at this moment to show all the options way forward, bearing in mind that we've not made any, you're perfectly within your rights to what you want to do. So I'll remit this to the work programme when we go into private session. Then we can have a very free discussion on processes, which it's a bit different. So we're going to do that. Where am I now? Yes, thank you. Item 5, consideration of evidence received in our next private session. We move into private session.